Hi everyone, how are you? Happy Sunday. Well, actually, I think I'm gonna put this out. Well, you know what? I might put it out tonight. I'll just do that. So we can continue to get as much work as we can done to get us ready for Tuesday. Oh, and Boo is gonna help us. Hi, Boo Boo. Hi, honey. Hi, baby. This is a very professional channel, Boo. You cannot get on my work, honey. Honey, hi. Hi. As suspected, that word that her attorney put in is not a word, the heightened. So when she has an attorney that has a big typo and then uses a phrase such as doesn't hold water or does hold water, it's not good. It just doesn't show me that this is a person who can properly defend a case that has $1 million at stake. Now, it is my opinion that if what Katie Joy is saying is true, then there's a huge problem. Okay, if what she is saying is true and she's bringing awareness to it, then obviously it's something that, as a social, I guess you would say that then she'd be a social activist by trying to bring attention to it. But and she's cited as it by her own attorney as a nationally recognized celebrity journalist. Okay, a journalist puts information, facts, and knowledge behind what they say. She doesn't. She just puts these allegations out there that are very serious, with no proof, nothing to link it to, nothing to say this is why I think this is it's always her sources. And never does she ever come out with who her sources are. A true journalist would come close. I mean, I know that journalists can protect their sources, but still they would say, this was said in this and this, and this was proven here, and this was this, and a source that, has this background and what, I mean, it's not enough that she says sources. She's always got these sources for these, outrageous things that she says. So I think she's in trouble. I think she's in deep trouble. I don't think that she has. I don't think that there was an attorney that was willing to put their name on her track history, because even if she's paying them and they lose, it's still a loss on their record. It's my opinion she's in trouble, like I say. Now, Boo Boo, I gotta see what I can read. Can you, please let me have my space here? Please? What's the matter, Boo Boo? He's been very loving today. I don't know why. He probably left me a turd somewhere that he feels guilty about. I don't know. Oh, this is not a professional page. Oh my God, do you not listen back to yourself? Like I say, that person was Kitty, not Katie, who said that. So I know that Katie is not looking at me and has no idea about who I am or anything. And she's not going to come after me. I know she wouldn't. Why would she? I mean, a journalist wouldn't. A real journalist would not do that. They would be able to stand on what they say and be able to defend it and be that social activist and say, yeah, this is what I found out. This is what's going on, and it's problematic, and this many people are affected, and this is what we need to do. And they would be making the appropriate connections with law enforcement to investigate and everything. And I just never see the follow through with that with her. So, with that being said, I'm going to start here on part 4, if I can get Boo to move over just a bit. Boo Boo looked like a Russian blue when I got him, so I thought he'd be a nice little friend for the mom and daughter Russian blues that I adopted. But it turned out later on, as he got bigger, he didn't look the same as them. And with his body shape, everything else, we looked up, and he's actually a co-rat. So he doesn't descend from a family of lions. He descends from monkeys. And as you guys can see, there's well, he's not doing it. Like earlier, he got over and he licked my tape. He does the craziest things. He's funny. He's very funny, but he requires so much attention. He is my love bug. I mean, he's very much like a dog. I'm sorry about all this cat hair all over. He's very much like a dog in his behavior, as you can see. And he gives me this cat hair all over, or his glitter, as I like to say it. I've got a glass of water here, and he gets really excited with glasses of water. He likes to stick his paw in it. Oh, he's wild. He's wild. So while he looks like one of my other silver cats, which are Russian blue, he's a korat. Korat. They were descended from Thailand. They are a good luck gift. The people give them as wedding gifts. They'll give a male and female korat to a couple, to a bride when they get married, as a sign of good luck. And as the legend goes, an American diplomat from Thailand was relocated back to the United States, or to the United States, and they brought their korat pair with them, and they got out, and in the 80s we started seeing korats here in the United States. So you don't see many of them. If you want one, you have to be prepared to, you can never leave them. I mean, he acts up terribly when I'm gone. I could never board any of the three cats. As my kids are in college, they can take care of the cats if we go anywhere. Because you could never board them. They would have so much anxiety that they would literally die. He had korat here as a boy. He had such an anxiety attack when the veterinarian tried to take him for a procedure. I thought he might have a UTI because of some of the terrible things he was doing. But it turned out he was just acting up because I was working too much. So him shitting in everybody's shoes was just a behavior thing. It wasn't that he had a UTI like I thought. He must have a bladder infection, right? Makes sense. So they took him to do a procedure, and he freaked out on them so bad and shit all over their walls and them, and freaked out that he put himself into respiratory distress. So then when he had a fishing hook stuck in his mouth, because he has to get into everything, and I was crying and I was hysterical, and I called the vet to bring him in, I found out that he is not allowed to go back to that particular veterinary clinic. I thought that they were cool about it. I thought that they had seen a cat that had done this before. I didn't know that they would block him. So they're saying, well, that particular cat cannot come back to our office. I'm like, he's got a fishing hook in him and he's in pain. And oh, God. And of course, as y'all know, animal emergencies only happen Friday at 5. So had to take him, and luckily I was able to go to a local veterinary clinic. I was heading down to a pet hospital, and I pulled over just there, and just in case, and they were so amazing, and they got the hook out, and they cut. There's a certain way you can get a fishing hook back out once it's stuck, and cut, and I didn't have to go through. So it was very, very nice. But anyway, so you guys just got a good old background of Boo. He's a huge part of my life. Everything revolves around Boo. Let me tell you that. I hope one of these days to buy him one of those circles, the big exercise circle that they have for cats. I want to buy him one so bad. Hopefully for Christmas I can squirrel a little money away and get him that. I got them the Robo, my kids call it the merry-go-round of cat shit. What is it? I'm sorry. I don't know if I explained this in my other video. I have really bad COVID brain still. I had COVID-induced meningitis, so my brain is still healing, and I have a hard time with words. So it's the automatic cat litter thing that goes in a circle, the robo litter, whatever. But it works great. It's so nice. You don't have the cat litter smell anymore at all. I mean, we were fastidious about keeping the litter box clean, but still, especially in the summer, there was always the odor. And the robotic thing is great. And the cats love it. Ma Kisses goes and tries to take a nap in it all the time. And then, that's the only problem with it. All right, sorry. Without further ado, here we go. Oh, this is a professional channel. I have to remember to be professional. Professional. Okay. And so we were going over here, and we are on page 10 of 13 in the memorandum in support of Paulson and Without a Crystal Ball's motion to dismiss. Okay. And we are starting right here, and I am going right here with that. So there we are. I'm going to leave that right here so we can see it clearly. And regarding similar intentional torts damaging a person, the United States Supreme Court has held that a public figure may not recover for the tort of intentional infliction of emotional distress without showing that the publication contains a false statement of fact which was made, with knowledge that the statement was false or with reckless disregard as to whether or not it was true. ID citing Hustler magazine. Ooh, Hustler, wow. Has great articles, right? That's the men get all their information from there, right? It makes them smart. Really smart. Come here, boo. Come here, love. You can sit with Mama. So, citing Hustler Magazine Incorporated versus Falwell, 485 U.S. 45 through 56 in 1988. The court goes on, nor can the fact that the defendant published the defamatory material in order to increase its profit suffice to prove actual malice. ID with emphasis added. I hope I did that appropriately on the emphasis. Although the concept of reckless disregard cannot be fully encompassed in one infallible definition, we have made clear that the defendant must have made the false publication with a high degree of awareness of probable falsity, or must have entertained serious doubts as to the truth of his publication. ID citing St. Armand versus Thompson, 390 United States 727 through 730 in 1968, and in Garrison versus Louisiana, 379 United States, 64 through 74 in 1964. That the plaintiffs have failed to include a single piece of evidence capable of proving that Paulson's alleged defamatory statements are known lies or that they were uttered in reckless disregard of the truth. Rose at 427. Rather, plaintiff has provided the precise opposite of that necessary proof, acknowledging Paulson reported on information from court documents. CAM complete at, what is that? Illicity? I can't remember. It's an illicity, isn't it? No, the other thing is an illicity. Oh, what is that? What is that symbol? I can't think of it right now. COVID brain. 25, table of claims, including that Paulson simply reported on court documents. So it's interesting that they don't cite what information she took from court documents. That is interesting to me. A little side note here. Because if we were to look at it objectively and look at this, what if what she's saying is true? And what if the other side is trying to figure out who told her what and when? And if what she's saying is true, what kind of a position does that put her alleged source in? I mean, I see that the court has to look at it through these eyes and be very, very open-minded as to the fact of, like, the court cannot, at this point, take into consideration her other lawsuits. They have to look at this unless and until to the point of them getting close to trial and them pulling what they can of the other lawsuits and get them admitted into evidence so that the jury would see that she has a pattern of reckless reporting. Without that piece, the jury would have to see this as no knowledge of her prior reporting, which, like I say, they will not have a problem finding a jury. Nobody knows who she is. Even when every time I went up to the courthouse to, familiarize myself with everything and get the documents and stuff, and I'll say, it's for this, and making sure that everything is open to the public and stuff, they have no idea who she is. They don't have any idea, even at the courthouse. Anybody locally who I have talked to about this, nobody knows who she is. So outside of the social media world, and I don't even think really in there, as you guys are seeing in my chats, I have people who have followed me through certain cases that I've done from the beginning, and so they are arguably on social media. They don't even know who she is. And I hadn't, and I've lived out here for 15 years. And me even, to the point where I was going to build a house down from her. I didn't know who she was or anything. Found that out afterwards when I recognized her address. But I would have built a house down the street from her, not known. It's not like, oh, that's her house. It's a very modest house, as I've said. It's really interesting. So yeah, they'll have no problem getting a fair and impartial jury. I don't think they'd have anybody who knows her history. So anyway, back to the script here. I remain professional. That, furthermore, plaintiff acknowledges that other businesses were convinced sufficiently of the veracity of Paulson's sources and information that they launched their own investigations into plaintiffs and cut ties with plaintiffs. AM complete at 25 through 69. This is what I'm talking about, is that it's one thing if somebody calls and says something, but I mean, because she brags that she called the Clippers and that they, in turn, terminated the 7M halftime show or whatever. She brags about who she called and told to effect this. She brags about the fact she's trying to bring them down. Now, one phone call doesn't necessarily warrant a big decision like that. Other calls do. So does she call and act like she's other people? Like Kitty? Or, I mean, what did they then find on their own investigation? Did they go and then they just find what she's written online and then she is the source that then is the source? Or is there other information out there that says the same thing? I mean, I see that there's a problem, but I still don't see that she has the protection or representation to get out of this. Anyway, the remainder of the plaintiff's amended complaint restates ad nauseum asserted legal conclusions that the alleged defamatory statements as a basis to allege a myriad of other claims, without providing a single actionable allegation under the standards of New York Times line of cases and Minnesota's adoption thereof in Rose. Instead, plaintiff relies on a series of assertions that provide no proof and no basis for meeting their burden to show actual malice as defined in the case law. For instance, plaintiffs rely on speculation as the basis for their allegations in the following paragraphs. And then we go through and we have 21 and 22 and 25 that all state on information and belief without any evidence. And then we have 23 and 24 that say claiming to know Paulson's mind without any evidence to support it in. And then the next one says and. Now, similarly, plaintiff complains repeatedly of Paulson's reporting on filed court documents without any explanation or allegation supporting the proposition that reporting on a court document is the basis for defamation sufficient to overcome the burden required by public figures making defamation claims or the fair reporting privilege. Again, simply reporting on information from a court document, whether confidential or not, is not sufficient to undergird. That's a word I've not heard. Undergird. is not sufficient to undergird a cause of action for defamation against a public figure, particularly in light of the fair reporting privilege, which applies to statements Paulson made that relate to those documents. And plaintiffs provide no basis for their allegations that court documents accessed by Paulson were confidential, nor how Paulson even obtained copies of documents covered by a protective order, which could only feasibly occur if one of the parties to an action broke privilege or violated the alleged protective order, an allegation which strains credulity. All right, we've got some fun new words to look up. All right, let's look up the word undergird. Undergird. Let's look up undergird, and let's look up credulity. Okay. And then what they're saying here is that fair reporting privilege. So they're arguing on the concept of fair reporting privilege. Let's look up that concept as well. Fair reporting privilege. And let's keep up with the lawyers here. All right, now we come over here. And we have, finally, Paulson's own statements about reports that she received directly from former members of 7M and the friends and family members of 7M, AM complete at 25, cannot be actionable under the New York Times line of cases and Rose because they have an even stronger defense. They are true. Okay, this is where they're going with this. And this is something interesting, because if they're going for that defense as well, that they're saying that what she's saying is true, then we've got a problem, because the other side essentially has to prove that they are not true. So it's really looking like, is it her that has the protective order on documents, or is it 7M? Because it seems like her attorney just implied that they have a history of protective orders. So, let's see. Let's see here, because they're very much giving an affirmative defense. They're saying she said these things, but they're defending it as being true. So, interesting. These statements, however disparaging, are not actionable. Stumpy's at 255. Each statement in paragraph 25 of plaintiff's amended complaint either A, is a true statement, or B, is taken from a public document, or C, Paulson's opinion. Okay, so now we have this as how they're going to defend her. They're going to say that these are true statements, however disparaging, are not actionable. That they are either A, a true statement, taken from a public document, or Paulson's opinion. Okay. For this reason, they cannot support a defamation claim under any theory of defamation available in Minnesota or form the basis of any related claim. Okay. Here we go. That's what they're going to defend. That's the hill they're going to die on, or stand on, and a defender. Interesting. Even the most favorable reading of the amended complaint's allegations. So even on the most favorable reading of the amended complaint's allegations, plaintiffs provide no basis for either 1, overcoming constitutional protections for the press, or 2, meeting their burden of proof in showing the existence of actual malice required for public figures. Okay, here we go again. Here's they're in a fighting mood, and this is what they're doing. This is their fight. This is what they're doing. Okay. All right. Got some power words there. And plaintiffs cannot prevail on tortious interference with the contract because they have pleaded no breach of a contract and have provided no evidence thereof. To make a claim for tortious interference with the contract, a plaintiff must show 1. The existence of a contract. 2. Knowledge of the contract by the alleged wrongdoer. 3. Intentional procurement of the contract's breach. 4. Absence of justification. And 5. Damages caused by the breach. Metke versus Cent, Neighborhood Improvement Associations 649 and W2D 488 500 in Minneapolis Court App 2002. Emphasis added. Okay, so we got some emphasis added here. Okay, this is the rest of their fight. This is how they're going. And you know that the lawyers in here, you know that they have. A firm is basically made up of elder members and newer members because you have this going on. Because, you know what a law library looks like. And now because we have computers and everything is, easier to just Google a word and a topic. But before that, every attorney has this big old bookcase and the little ladder that goes back and forth because it's hard to know case law. And that's why you have the senior members who would be able to consult in this and say, okay, well, yeah, I remember that, when this happened back in 1968, or I remember when Hustler took, this, and I remember when the New York Times did this, and it's stated here, and then case law was set here and that, because that's not something that you are taught in law school. You're taught the basics, and then the research from that and how to procure that research is of course taught, but they can't teach you every single case that's been heard and how that made this and that unless it's a very, very big thing. But for them to be talking about these cases that none of us would know about in our everyday procedures, and only 4 years of law school, you can't really fill that all in. You're mainly learning proper procedure and how to defend in civil and criminal. Now, it says here that there is no allegation in the amended complaint that the Clippers contract was breached. Oh, in the amended complaint, they left that out. Oh, I did not notice that. I'm going to have to go back and look at that. Because it says there's no allegation in the amended complaint that the Clippers contract was breached, nor is it likely that it was breached, given the common escape provisions in commercial entertainment contracts. Without the contract to review or an allegation of breach of the contract, defendants cannot make a showing for element 3 of their cause of action and their claim fails. Okay. So what they just used here is another power word. They use the word element. So when you are proving a civil or criminal case, there are elements of the case that you must prove. And if those elements of the case are not proven, you cannot reasonably expect to win. Now, when I was thinking about this, and wondering how they were coming up with the number of $1 million, it seemed really a no-brainer when you think of them losing a contract for the halftime show at the Clippers games. That right there is probably an easy several $1 million that we're talking about. Now, if they left that out, then they have more of a burden to show where they're coming up with that $1 million issue. Now, an old rule of thumb was you figure actual damages and times it by 3 to ask for a settlement. So the easiest way to think about it is your personal injury car accident. Okay? Civil case, personal injury, you got rear-ended, you have $3,000 in medical bills. Okay, so your attorney is going to ask the other party's insurance company to give you $9,000. That, basically your $3,000 is a no-brainer. It covers the the medical bills. Now, what we don't always consider here is that attorneys take most personal injury cases on a contingency basis. So they are going to get 1/3 of what you get. So if you have $3,000 in medical procedures that you can easily prove, that $3,000 goes there. Your attorney takes 1/3 of it, and you are left with $3,000 as a compensatory. Sorry this happened. Sorry for your inconvenience and your lifelong pain. Here's $3,000 to make you feel better or to use for other non-traditional medical treatments, as as it is. Now, in a civil case such as this is not going to be on a contingency. This is something that she has to pay. So she is paying every single step of the way. I can't think of a reason why something like this would be on a contingency unless we're talking about I am here. There's a person who's very litigious on our YouTube streets, as we all know, Blowhorn Betty. If anybody dares to even laugh at her or, throw shade at how she tries to interject herself into high-profile crimes so that she can get a lot of money from her subscribers, and she'll probably sue me for saying that, and I don't give a flying whatever. It's true. It's easy to see that's what she does. And so anybody who speaks out against her, she goes after them. She struck my channel once just for speaking out about how I thought it was obscene what she was doing, and commanding that the next time somebody brought donated food by, that they make sure that it's hot from a local restaurant, when she was sitting outside terrorizing the neighborhood of Leilani, the one who basically her 2-year-old ended up in a landfill. So they were in Leilani's neighborhood making absolute asses of themselves and running basically a scamathon where everybody was calling in and giving them money, and people were calling local restaurants and having food sent to them, and Blowhorn Betty yelled, "Make sure it's hot next time." And I thought it was disgusting that, she was being paid to go there, paid to sit on her ass there, paid to sit there and be obnoxious and screaming a bullhorn, paid to eat, paid to sit there and just do that. And one of the residents of the neighborhood, a lifelong neighborhood resident, was on hospice and was just trying to die peacefully, and they couldn't die quietly because Betty wouldn't shut up. So this poor person on hospice had to call 911 and ask to be transported to a nice quiet place where they could go die. And my problem is that the people in the neighborhood didn't do anything wrong. If they want to protest, then go protest at City Hall or the police department, or write up something online and have people, have awareness. But to sit there and command money so that you can sit there and run a 3-ring circus, which boils down to nothing but giving them a bunch of money that they can't account for, and it funds the other things that they do, and many activities that they do with that money. So I spoke out about it, and my channel was struck down. I was struck down entirely and shut down for 3 days, and it was really hard. I think I was at 500 subs then. I didn't really understand what had happened or why, and it just comes down when you get your channel shut down that it says you're done. You can't have a backup channel. You can't be on YouTube. Nice knowing you. Don't ever come back. Don't ever even try. So she struck mine and many other channels in that same week, her and her little gaggle of flying monkeys. So I could see when she does her frivolous lawsuit thing, because she represents herself pro se. She says that she used to be a paralegal for a prominent judge. That's questionable at best. The college she attended is not reputable, and this judge has never been located. So she is currently filing a lawsuit against Queen Bee, another YouTube creator, basically because Queen Bee was laughing at her for something else. So she is filing suit in that, and other creators came together to put together a fund to hire representation for Queen Bee. Because at the very least, if somebody files a lawsuit against you like this, you're out all of the money. And so the community came in support of Queen Bee to get her that money. And I know people are questioning that and whatnot, but I have seen the documents that she did procure representation. So Queen Bee did procure representation. My point in all of this is that the only way that I could see in a case like this being on a contingency basis is if an attorney in the YouTube community or otherwise saw somebody as litigious as Betty and knows that it's a no-brainer that they're going to win, them taking the case on a contingency basis so that they could smack down Betty and teach her a lesson. That's where I could see it being on a contingency basis. Other than that, I don't see how it wouldn't be on a contingency basis. And Katie has probably already paid. I mean, I was thinking 30 to 50,000, but I don't even know at this point because of how much has been back and forth. I really don't know. And then if she loses, she's responsible for their legal fees and the settlement. So I don't know if she has a good policy in her LLC that protects her from this, and she just figures it's a claim against that each time, but it's going to be a matter of time. No one's going to insure her in the LLC. So that's my opinion. So now we're to the conclusion of the memo. And we say, the conclusion. For the foregoing reasons, defendants respectfully request that the court grant their motion to dismiss for failure to state a claim on which relief may be granted and dismiss all plaintiffs' claims with prejudice. Respectfully submitted on April 26, 2022. So a year and a half ago, they were to this point. And it was submitted by Troutman Martin Law, by Kristen Hendrick, Graham Martin, and they are on South 10th Street in Minneapolis. And they are the attorneys for defendant Catherine Paulson. Now, this has a Minnesota statute 549.211 acknowledgement where it says the party on whose behalf the attached document is served acknowledges through its undersigned counsel that sanctions, including reasonable attorney's fees and other expenses, may be awarded to the opposite party or parties pursuant to Minnesota statute 549.211 in 2016. And again, signed by Kristen Hendrick at Troutman Martin Law. So they acknowledge that she may have to pay their attorney's fees if she and the settlement if she's wrong. So I'm going to stop right there. I've got some other things I've got to wrap up around the house, and then I will come back here and we will start 5 on this page here. We will start number 5. Thank you for your patience and allowing me to love my boo. He is nicely sleeping at my feet right now. And we'll start number 5 here in the memo of law in opposition to the defendant's motion to dismiss. And that ought to be really juicy. So I'll talk to y'all again soon. Thanks for listening. Bye-bye.